Is permanent resident status really permanent in the United States? Hi, I am Maxwell Korveh, a licensed lawyer practicing immigration law, employment law, and personal injury law. The answer is no. Permanent resident status, also called a green card status, is not permanent in the U.S. I tell green card holders not to wait a day more than necessary to apply for citizenship when they become qualified to apply, because permanent resident status in the U.S. is nothing more than a borrowed time in the U.S. and not at all permanent. The word permanent in permanent resident status has close to zero applicability to your resident status in the U.S. Your green card is like a green light that can turn into a red light at the least mistake and turn your American dream into a nightmare. Take a look at your permanent resident card. You will see it has expiration date on it. That tells you your permanent resident status in the U.S. Is not permanent. You will have to renew it periodically. Your renewal application can be denied, and in some instances, you will be placed in deportation after your renewal application is denied. Contrast that with your citizenship certificate or a citizenship certificate. There is no expiration date nor the need to renew a citizenship certificate because it is deemed properly deemed a permanent status. Do you know you can't even really come and go out of the U.S. as you please with your permanent resident status? What do I mean by that? I mean, you cannot even spend time outside of the U.S. as long as you want with your permanent resident status, because staying out of the U.S. over an extended period of time beyond what is permitted by law may lead to the loss of your permanent resident status by what is called in the law abandonment. In U.S. immigration law, there is a presumption that a person intends to abandon their permanent resident status if they stay overseas for an extended period of time and fail to maintain sufficient ties with the U.S. To show that they consider the United States to be a permanent home. So DHS will make that determination by looking at the length of your absence from the U.S., the reason for your absence, evidence of your scheduled return to the United States, if any, whether you continue to pay taxes or file tax return as a U.S. permanent resident, whether you maintain property in the U.S., the location of your employment, the location of your family, and other relevant factors as the basis to revoke or terminate your status in the U.S. If you are a permanent resident of the U.S. planning an extended trip outside of the United States, it is a good idea to talk to an immigration lawyer before you embark on your trip. Another thing that you need to be mindful of is that criminal conviction or guilty plea can cost you your permanent resident status. You are probably thinking, criminal conviction? I would never commit a crime. Do you know how many people are wrongfully convicted in the U.S. for being at the wrong place, probably at the wrong place at the wrong time? In some instances, you do not even have to commit a felony or a crime of moral turpitude to risk losing your permanent resident status and or getting deported. Making assertions or representation of facts that is not completely truthful to immigration when later uncovered may constitute grounds for deportation or revocation of your green card. So think again. A misunderstanding at home with tempers flaring may lead to a domestic violence case against you. A well-intentioned attempt to help a family or a friend to enter and live in the U.S. if determined to be by unlawful means exposes you to deportation offense called alien smuggling. Do you know assisting a person to illegally come and live in the U.S. constitutes what is called alien smuggling, which is a deportable offense? Do you know habitual drunkenness and the use of prohibited drugs can get you deported if you're a permanent resident of the United States? A misguided attempt to pay less taxes may lead to tax fraud charges against you. Because life is precarious and life is quite unpredictable sometimes, and you are not perfect, you should obtain your citizenship as soon as practicable when you become qualified. But a quick note of caution to you. A lot of people think that once they obtain their green card, pay their taxes, do not commit any crime for the next 3 or 5 years, then they are all set to go ahead and file for U.S. citizenship and be approved without any problem. That thinking is too optimistic and a little dangerous. Because naturalization or citizenship application invites a lot more heightened scrutiny. Because it is the last step to cementing your stay and belonging in the U.S. And it is USCIS last chance to thoroughly vet your eligibility to see if you have any issues in your background that preclude you from becoming a citizen, or any issues in your background that preclude you from becoming a permanent resident in the first place. USCIS is going to pull up all your old files and go back to analyze how you got your green card, re-examine your background as far back as when you initially entered the United States. If USCIS uncovers any discrepancies in your answers or evidence you provided relating to your green card or citizenship application, that can trigger a big problem for you. Depending on the seriousness of the issue or mistake uncovered, USCIS can deny your citizenship application or revoke your green card and move to put you in deportation. So I would suggest you consult a competent immigration lawyer before you proceed with your citizenship application. If you ever need any help with immigration petition, give me a call on 415-528-2511, and I'll be happy to help you. Be sure to subscribe or like my channel for more immigration answers. Good luck.